Right now, a major discovery tied to the lynching of Emmett Till. It's trending all over social media.
The family of the slain teen is demanding an arrest after an unserved warrant was discovered 66 years later. That warrant charged Carolyn Bryant Donham in his 1955 kidnapping.
Relatives of Till want authorities to use that old warrant to arrest her now. At the time of Till's death, she was married to one of the two white men, tried and acquitted by an all-white Southern jury.
Carolyn Bryant Donham set off the case in August 1955 by accusing the 14-year-old Till of making improper advances at a store in Mississippi.
Right now, she is in her 80s and most recently known to live right here in North Carolina. Several people are wondering what this recent discovery of the old warrant means, so let's dig deeper with the legal experts.
We're joined live by Jason Keith with Keith and Associates. So Jason, the Till family wants law enforcement to serve Miss Carolyn Bryant Donham with the current warrant. Could this actually happen?
Actually, it actually can happen. The warrant was actually issued in Mississippi, and assuming that the warrant hasn't been dissolved and that it's still active, the warrant actually should and could be served by North Carolina law enforcement officers.
So there's not a statute of limitation on that case then?
Mississippi law governs, but for the most part, generally no. Stale warrants are usually served. They usually stay alive until they're actually served on the individual in the cases.
And what would that process look like? I mean, could North Carolina initiate it since she's here, or would it have to come out of Mississippi?
So what would generally happen is Mississippi would send a warrant to North Carolina. North Carolina would respond by issuing the warrant on behalf of Mississippi upon Ms. Donham, because Mississippi is the actual issuing state that actually wants Ms. Donham to actually report back and potentially be held accountable for crimes.
So a lot of people are talking about this. Is there any notable civil rights case in which someone was brought up on charges that happened 70 plus years ago?
Well, in terms of civil rights, there are, but more specifically, it's not uncommon. I mean, you can think about Holocaust cases, and you can think about other cases where there are older cases, there are older crimes, and new evidence has resurfaced, or the original warrants were never actually served on individuals. So it's not uncommon. Old cases that potentially they never were actually brought to trial for have actually been tried, and warrants have actually been served on individuals in the recent years. So it's pretty common, actually.
So lots of people on social media I've seen have been saying, who do we need to reach out to and lobby to get them to actually do this?
Good question.
Well, keep applying pressure to the legislature and the people and the officials in Mississippi. North Carolina is not going to actually respond to a warrant or execution of a warrant unless Mississippi asks them to. If the warrant is still alive, it hasn't been dissolved, it's still, if the warrant is still there, they can just ask law enforcement officers in North Carolina to serve it, and they will actually serve Ms. Donham and potentially have her arrested.
Well, lots of interesting perspective, and we're so lucky to have you here today. Thank you so much.